Hello, my name is Emily, and this is my presentation on right to farm laws and environmental justice. I'll specifically be focusing on analyzing the landmark case of McKiver and Murphy Brown that took place in North Carolina. So, what is the right to farm? First introduced in the late 1970s, right to farm laws were developed in the response to an increase in people moving from city centers to suburban and rural areas. When this occurred, there was an uptick in court proceedings initiated by the new residents against local farms that were already established in the area, claiming that the sights, smells, and sounds associated with farming were a nuisance. Before the right to farm laws existed, many small farmers were forced out of business due to the high costs associated with the lawsuits. Right to farm laws were then established to protect farms from frivolous lawsuits. First established in New Jersey, the laws were soon adopted in some form by all 50 states. They vary greatly state to state, creating a patchwork of protections across the country. For this paper, I utilized the framework established by the National Agricultural Law Center to help analyze key features of North Carolina's right to farm laws. The National Agricultural Law Center created a guide for classifying important categories of the right to farm laws of all 50 states. Through this mechanism, they were able to highlight key concepts, compare trends, and major features. I chose to focus on North Carolina because pig farming is a major component of North Carolina's economy. The laws in North Carolina were written by Wendell Murphy of Murphy Brown Farms, a subsidiary of Smithfield, which operates CAFOs, or concentrated animal feeding operations, usually after buying out or renting pre-existing small farms. This slide shows some of the key features of the law. The most contentious aspects include the statutes of repose, which state that a case cannot be filed if the farm has existed for over a year, unless major changes such as a change in production or tools used occurs. The preemptive clause means that the right to farm law takes precedent over any later established law that may interfere, and most significantly are damage caps. This statute is not present in many states, only 7, and its constitutionality has been called into question. It states that all compensation awarded to plaintiffs cannot exceed the fair market value of the farm in question. This severely limits the amount of compensation that a plaintiff can obtain, and this will be seen in the McKiver case that I examined. In North Carolina, CAFOs are concentrated in the eastern part of the state, mainly in Duplin County. The residents living in these areas, and therefore near the CAFOs, are predominantly low income and predominantly people of color. Majority of residents living here are Hispanic, Black, or Native Americans. Due to the proximity, these groups of people living near the CAFOs are subject to a disproportionate share of the negative impacts these farms have on the environment and health. As you can see in the images, there is a correlation between impoverished areas and areas with a high density of hog operations. Research has also shown that CAFOs are 9 times more likely to be in areas with low-income residents of color. This is in part due to the fact that the farms in these areas are cheaper for bigger farms to rent or buy. In 2018, the McKiver and Murphy Brown case became one of the first nuisance lawsuits against a CAFO to rule in favor of the plaintiffs, which was a major victory for the impacted community members. They were living in dangerous and intolerable conditions, which began occurring after the CAFO operations were established at smaller farms that had already existed in the community. The residents were subject to unbreathable air, massive swarms of buzzards and flies, putrid smells as a result of animal waste being sprayed on the fields, open pits of animal waste throughout the property, and dead boxes, which are boxes containing dead pigs left to decompose throughout the farm. The case represented 26 plaintiffs who filed a mass action lawsuit against Murphy Brown and were awarded $453.5 million in damages. However, due to the damage cap statute, this was reduced to only $2.5 million. Murphy Brown attempted an appeal, but the judge again ruled in favor of the impacted communities. This was a historic case for environmental justice. These communities have long been at the forefront of the movement and have finally secured a victory for the low-income residents of color who have been at high risk of health issues due to the intolerable environment caused by farming operations. 26 subsequent cases have been filed since, and experts in the field are confident that they will also be ruled in favor of the plaintiffs. During the appeals case, Judge Wilkinson gave an empowered speech, which shed light on the environmental justice movement. Judge Wilkinson acknowledged the political, racial, social, and economic disparities present that have exacerbated the plaintiff's circumstances. The quote reads, "If this were my property, I'd be outraged at some of these conditions that were allowed to persist. Less fortunate citizens have property rights too. They have a right to good health and enjoyment of their property. If this were some McMansion surrounding hog farming operations, or houses of the affluent and more politically powerful were here, wouldn't these conditions have been cleaned up sooner rather than later? That is my problem." Moving forward, I think it is necessary to create a balance between the interests of major farming operations and the health and safety of residents living close to CAFOs. When reviewing some of the key components of right-to-farm laws across the United States, it became evident that certain protections for people that are present in the laws of other states are not included in the laws of North Carolina. The inclusion of any or all of the following potential statutes could empower the people of North Carolina to better advocate for their own health. For example, other states ensure that farms must adhere to state and federal farming regulations. They must follow good agricultural practices, which would also be defined by the state. The establishment of stricter guidelines would help to keep residents safer and farming operations less hazardous. Lastly, and most relevant to environmental justice and health, refers to public health and safety. It indicates that if the farming operation has an adverse effect on public health or safety, as was seen for the residents of North Carolina's Dublin County, the farm will not be protected from a nuisance suit. And here are my references. Thank you for listening, and I hope you enjoyed my presentation on the right to farm laws in North Carolina.